Welcome to Business Law Study Section 7. At the end of this study section, we should be able to cover the following. 1, we should be able to explain the meaning of disclosed principle and undisclosed principle. 2, we should be able to discuss agency coupled with an interest. 3, we should be able to explain delegation of authority. 4, you should be able to highlight the rights and the duties of the principal. Number 5, you should be able to state the duties and the rights of an agent. Number 6, you should be able to explain the relationship between the agent, the principal, and the third party. Lastly, we should be able to discuss termination of agency. These are what we are expected to know at the end of this study section. We are starting with the first aspect, disclosed and undisclosed principle. Who is a disclosed principal? A disclosed principal is a principal whose name is known or his identity is known by the third party as at the time he's entering the contract with the agent. A disclosed principal is a principal whose name is known or his identity is disclosed to the third party as at the time the third party is entering the contract with the agent. It is clear at that point that the agent is not dealing with the third party within his own capacity, but is acting on behalf of a principal. You have to take note, it is not important for the third party to know the name of the principal. What the third party needs to know is that the agent is acting on behalf of a particular principal and is not acting on his own behalf. In that case, where the agent is acting on behalf of the principal, the agent cannot sue and the agent cannot be sued in that particular contract. Where the agent is acting on behalf of a principal, the agent cannot sue and be sued in that contract. Then we'll talk about an undisclosed principal. Who is an undisclosed principal? This is a person that is not disclosed to the third party by the agent as at the time he was making the contract with the third party. In this circumstance, the agent gives the third party the impression that he is the principal and is not acting on behalf of any other party. What is the remedy available to the third party under this circumstance? Where there is an undisclosed principal, the third party that suffers loss can bring an action against the agent and also against the principal. We now move on to look at agency coupled with interest. What is an agency coupled with interest? This arises where the principal engage an agent and promise him of a particular thing or have a security with him. The extent of this is that the principal cannot terminate the relationship with the agent until he fulfills whatever he has promised the agent. What we are trying to say in essence is this: where the principal promises a particular thing to an agent for the agent to carry out his duty, after the agent has carried out his own duty, the principal cannot terminate the agency relationship until he fulfills the interest or the promise he has made to the agent. We move on to look at delegation of authority. What is delegation of authority? It arises where a person with an authority gives another person to act on his behalf. That is what is called delegation of authority. But the general rule is to the effect that you cannot delegate an authority that is delegated to you. The general rule is to the effect that you cannot delegate the authority that is delegated to you. So we maintain the principle that you cannot delegate delegated authority. It's on the maxim of law, delegatus non protest delegare, meaning that you cannot delegate the authority that has been delegated to you. But there are exceptions under the circumstance for which you can delegate delegated authority. There are exceptions, there are grants that will permit you to delegate the authority that is delegated to you. Here we have 5 exemptions under which delegated authority can be further delegated. Number 1, where the custom and the usage in the trade allow such delegation. So where the trade allow you to delegate authority in order to achieve objective, that delegation is viable. Number 2, where it is necessary or exigent to compel the agent to adopt that substitute. It could be important that in order for the agent to achieve the goal of the principal, he needs to delegate the authority. Under that circumstance, the agent can delegate the delegated authority. Number 3, where there is an express and implied authority by the principal to delegate, we are saying that naturally a delegated authority cannot be further delegated, but where the principal that engage the agent gives authority to the agent to further delegate his power in order to achieve the objective of the principal, that delegation will be said to be valid. Number 4, where the delegation is pertinent in order to attain the agency goal, where it is fundamental that when the agent delegates the authority that has been delegated to him, he will be able to achieve the goal of the principal, that delegation could be accepted under the exception of the rule of delegation of authority. Where statutory provision empowers delegation, where there is a law that empowers the agent to delegate the authority that has been delegated to him, such delegation is also said to be valid in law. What are the duties of a principal in the principal-agency relationship? If an agent if a principal engages an agent to act on his behalf, what are the duties of the principal? Number 1, it is the duty of the principal to pay the reward or the commission of the agent. That is the number 1. It is the duty of the principal to pay the reward or the commission of the agent. Number 2, it is the duty of the principal to indemnify the agent for any out-of-pocket expenses, meaning that when an agent spends money on behalf of his principal, it is the duty of the principal to pay back the agent for any out-of-pocket expenses that is incurred. Number 3, it is the duty of the principal to ratify any act that is carried out by the agent on his behalf. That when an agent carries out an assignment on behalf of the principal, it is the duty of the principal to ratify any act that is carried out by the agent. Number 3, where the principal is a disclosed principal, where the principal is a disclosed principal, it is the duty of the principal to take responsibility of any act that has been done by the agent. Number 4, it is the duty of the principal to enforce the contract against the third party. It is the duty of the principal to enforce the contract against the third party. And number 6, as a general rule, the principal is liable to the third party under the contract whether or not the principal is disclosed. We move on to look at the duties of the agent. That if an agent is engaged by the principal, what are the duties of the agent? Number 1, it is the duty of the agent to obey the orders of the principal. It is the duty of the agent to obey the order of the principal and its instructions. It is also the duty of the agent not to delegate the authority that has been delegated to him. Number 3, it is the duty of the agent to exercise due care and skill in the performance of his duty. Number 4, it is the duty of the agent not to make secret profit in the course of the activities that he does on behalf of his principal. Number 5, it is the duty of the agent not to disclose confidential information that he was able to receive on behalf of his principal. Number 6, he should render account to his principal as at when due. It is the duty of the agent to render account to his principal as at when due. Now we want to look at what is the relationship between the agent, the principal, and the third party. Number one, where an agent has contracted as an agent, he cannot be liable personally to the contract. In other words, where an agent has disclosed to the third party that he is an agent acting on behalf of a principal, he cannot be held liable for any act that he carried out in that particular contract. However, if he had no authority to contract, he will be personally liable. In other words, in the first instance, where he has authority to contract and he disclosed his principal and he acted on behalf of the principal, he will not be liable to any action. But where he lacks authority to contract what he has contracted with the third party, he will be personally liable to that action. And if the agent knew, as at the time he had no authority and he went on, he will be liable to deceit in thought. We now need to maintain the legal position. It's to the effect that when the principal is disclosed, the third party cannot set up the debt against the agent. Where the principal is disclosed, the third party cannot set up the debt against the agent. But where the principal is undisclosed, the third party has a right to regard the agent as the principal. We now move on to termination of agency. We move on to look at termination of agency. And when you are talking about termination of agency, you are referring to a situation where the relationship between the principal and agent comes to an end under the law. Under the law, there are two circumstances that could lead to termination of agency. Under the law, there are two circumstances that could lead to termination of agency. Number one, by the conduct of the parties. Number two, by the operation of the law. Number one, by the conduct of the parties. Number two, by the operation of the law. Then, under the conduct of the parties, we have three classifications. Under the conduct of the parties, there are three classifications. One, through mutual agreement, meaning that there could be an agreement between the agent and the principal that the relationship could come to an end. In that circumstance, the relationship between the principal and agent could come to an end. So mutual agreement between the principal and the agent could bring the relationship to an end. Number two, it may also be by giving necessary notice of the contractual agreement. The agent may give the principal notice that he wants to terminate the relationship, and the principal can also give the agent notice that he wants to terminate the relationship. Another method under the conduct of the parties is the revocation of authority. It is very clear that it is the principal that gives the agent the authority to act on his behalf. So the principal can revoke the authority that the agent should no longer act on his behalf. At that circumstance, the agency relationship will be terminated. Then we now come to under the operation of law. Under the operation of law, agency could be terminated in 6 categories. Under 6 heading. Number one, through the death of one of the parties. If the agent or the principal died, the relationship will come to an end. Number two, by insanity of one of the party. If one of them goes out of mind or is mad, then it does not have the capacity to continue. Relationship can also be terminated. Number three, through bankruptcy of one of the parties. If one of the parties becomes bankrupt and so upheld by the court, then the agency will come to an end. Number four, by frustration. If the subject matter is being destroyed by nature or by any act which is not the fault of both parties, the agency could also come to an end. Number five, if the action becomes illegal, maybe what brought them together initially was legal, but when it has been subsequently declared illegal, the agency relationship could also come to an end. And number six, where the subject matter does no longer exist. Where the subject matter does no longer exist. what brings them together does no longer exist, agency could also be terminated. And number 7 is the expiration. That is, if the relationship is entered for a specific period, at the expiration of that period, the agency will come to an end. So thank you very much. We shall meet again in the next class. Thank you. God bless you.